So as André mentioned, I will be addressing competence competence from the US law perspective. Unlike the UNCITRAL model law and arbitration statutes in many other jurisdictions, the US Federal Arbitration Act, or FAA, does not expressly address the competence competence of arbitral tribunals. US courts, including the US Supreme Court, have, however, repeatedly upheld the doctrine. I'm going to focus on the US Supreme Court's recent decision in Henry Schein versus Archer and White Sales and whether it changes anything in the US approach to competence competence. But before I do that, I thought I would give a bit of background on the prior state of the law. The foundational case in this area is the US Supreme Court's 1995 decision in First Options of Chicago v. Kaplan. I should note at the outset that although First Options and subsequent cases all address domestic arbitrations, these principles have also been applied in international contexts. In that case, First Options had entered into an arbitration agreement with MK Investments, an investment company wholly owned by Manuel Kaplan and his wife Carol. When a dispute arose, First Options brought an arbitration against both MK Investments and the Kaplans personally. The Kaplans objected to the tribunal's jurisdiction on the basis that they had not signed the arbitration agreement. The arbitral tribunal, however, rejected this objection and proceeded to issue an award in First Options' favor. The question for the Supreme Court was the proper standard for the courts to apply in reviewing the arbitral tribunal's decision on arbitrability, which I should note in this context refers to the question of whether a particular dispute is subject to a valid arbitration agreement. First Options was pushing for a deferential standard of review, like the one courts applied in reviewing arbitrators' decisions on the merits, whereas the Kaplans, unsurprisingly, favored de novo or independent review. The Supreme Court explained that the parties to an arbitration agreement are free to specify that the arbitral tribunal, rather than the courts, will decide arbitrability. In such a case, this agreement should be enforced, and a court reviewing the arbitral tribunal's determination of these so-called gateway issues should therefore apply the same deferential standard that would apply to review of the arbitrator's other determinations, including on the merits. However, the default approach in the United States is that questions about the existence, validity, and scope of an arbitration agreement will be decided by the courts. As a result, in determining whether the parties agreed to arbitrate these issues instead, the Supreme Court has required clear and unmistakable evidence that this was the parties' intention. This approach is in contrast to the pro-arbitration bias, where a concededly valid agreement to arbitrate exists, and the question is the scope of that agreement. In the latter case, the presumption is that any doubts concerning the scope of arbitrable issues should be resolved in favor of arbitration. The Supreme Court justified this difference in approach on the basis that where a valid arbitration agreement exists, this shows that the parties, quote, likely gave at least some thought to the scope of arbitration, such that a presumption in favor of arbitration made sense. In contrast, the court considered the question of who decides arbitrability as rather arcane and something the parties might not have considered. As a result, the court refused to interpret silence or ambiguity in this respect as reflecting a desire to arbitrate issues that a party would otherwise expect a court to decide. In Howsam v. Deanwitter-Reynolds, issued in 2002, the court clarified the category of arbitrability or gateway questions that are subject to the requirement of clear and unmistakable evidence of the party's intent to submit them to an arbitrator. As the court acknowledged, linguistically speaking, one might call any potentially dispositive gateway question a question of arbitrability that would trigger this presumption. The court has, however, interpreted the phrase in a more limited way to apply in the kind of narrow circumstance where contracting parties would likely have expected a court to have decided the gateway matter, where they are not likely to have thought that they had agreed that an arbitrator would do so, and consequently, where reference of the gateway dispute to the court avoids the risk of forcing parties to to arbitrate a matter that they may well not have agreed to arbitrate. In practice, this has meant that fundamental questions of whether the parties are bound by a given arbitration clause or whether an arbitration clause in a concededly binding contract applies to a particular type of controversy is for the court, absent clear and unmistakable evidence of the party's contrary intention. In contrast, so-called procedural questions like time limits, waiver, delay, and the satisfaction of conditions precedent are generally presumptively for the arbitrator, again, absent an agreement of the parties otherwise. The Supreme Court reiterated these principles in 2010 in Rent-A-Center West v. Jackson, emphasizing the separability of the arbitration agreement from the remainder of the party's contract. The Supreme Court held that a court will only intervene, for example, to determine the validity of the agreement to arbitrate, where a challenge is made to the arbitration agreement specifically. Because the plaintiff in that case argued that the agreement as a whole was unconscionable, without any reference to the specific provision delegating all disputes, including regarding enforceability, to an arbitrator, the Supreme Court held that the parties' agreement must be enforced and that the question of unconscionability was for the arbitrator rather than the courts. The basic approach, then, is that courts presume that parties intend the courts to decide fundamental threshold issues like validity and enforceability. But as the Supreme Court has said many times, arbitration agreements are contracts, and if there is clear and unmistakable evidence that the parties intended to submit certain issues, including arbitrability, to the arbitrators, the courts will enforce that agreement and defer to the arbitrator's ultimate decision. With that brief background, I turn now to Henry Schein versus Archer and White Sales, decided on the 8th of January, 2019. In that case, Archer and White, a small dental equipment distributor, sued Henry Schein Incorporated and another company for alleged antitrust violations. Archer and White sought both money damages and injunctive relief. The parties' arbitration agreement included a carve-out that applied inter alia to, quote, actions seeking injunctive relief. Henry Schein nevertheless asked the court to refer the parties to arbitration on the basis that the carve-out was limited to lawsuits where the only relief sought was injunctive. The question then became, who should decide whether the antitrust dispute was subject to arbitration or not, the court or an arbitral tribunal? Henry Schein argued that the Contracts Incorporation of the American Arbitration Association's rules, which provide that arbitrators have the power to determine their own jurisdiction, meant that the arbitral tribunal must decide. Archer and White responded that in cases where the defendant's argument for arbitration is wholly groundless, which Archer and White argued was the case here, the court itself may resolve the threshold question of arbitrability. The trial court agreed with Archer and White, both on the existence of a so-called wholly groundless exception to a delegation of arbitrability to a tribunal, and on the wholly groundless nature of Henry Schein's argument for arbitration in that case. The Court of Appeals then affirmed. The Supreme Court took the case to resolve the disagreement among various courts of appeals as to whether this wholly groundless exception is consistent with the FAA. The Supreme Court rejected the exception on the basis that the FAA requires agreements to arbitrate to be enforced like any other contract, including provisions on arbitrability. Even where a court considers the argument for arbitration to be frivolous, it is not entitled to override the language of the parties' agreement. Assuming the court finds that a valid arbitration agreement exists, the court must enforce that agreement according to its terms. In reaching this decision, the court rejected policy arguments put forward by Archer and White to the effect that the wholly groundless exception would favor the efficient and cost-effective resolution of disputes by discouraging frivolous motions to compel arbitration and by eliminating the need for an arbitrator essentially to go through the motions before sending the dispute back to the courts where it belonged. As the Supreme Court explained, it is possible for two fair-minded decision-makers to come to different conclusions on the same issue, and even for both decision-makers to consider the correct outcome to be obvious. Thus, it cannot be assumed that just because a court considers a reference to arbitration to be wholly groundless, that an arbitrator would necessarily agree. Moreover, the court recognized that arbitrators can efficiently dispose of frivolous claims by promptly dismissing them and can impose fee-shifting and cost-shifting sanctions where appropriate. The Supreme Court accordingly deemed Archer and White's concerns overstated. By emphasizing the contractual nature of the agreement to arbitrate and the need to enforce the parties' agreement as written, Henry Schein is in line with the court's earlier jurisprudence. In fact, the court referred expressly to prior decisions in which it had rejected a similar exception to the FAA, where the court sought to avoid referring a dispute to arbitration because it deemed the claim on the merits to be frivolous. Following Henry Schein, however, lower courts have taken diverging views of arbitration agreements that include both a clause delegating arbitrability questions to arbitrators and a clause carving out certain kinds of disputes, usually requests for injunctive relief, from the parties' agreement to arbitrate. Some courts have held, in light of the delegation clause, that they have no authority to determine whether the carve-out has been triggered. Other courts have considered that there's a clear contradiction between the two clauses, such that there cannot be said to be clear and unmistakable evidence of the parties' intention to delegate arbitrability issues to the arbitrators. These cases suggest that although the reasoning in Henry Schein follows from the Supreme Court's earlier cases, its application may not always be as clear as the court's discussion there suggests. The other key question after Henry Schein is whether the incorporation by the parties of arbitration rules providing for the arbitral tribunal's competence is enough to demonstrate the required clear and unmistakable evidence of the parties' intent to remove these issues from the court. As I mentioned, the contracted issue in Henry Schein incorporated the AAA rules. The Supreme Court, quote, expressed no view about whether the contracted issue in fact delegated the arbitrability question to an arbitrator. It therefore remanded that question to the Court of Appeals. The majority of courts have held that such incorporation is sufficient to demonstrate the requisite intent, but the third restatement of the U.S. law of international commercial arbitration has taken the contrary view. This is an open issue that may need to be determined in a future Supreme Court case. So what does all this mean for uniformity? In broad strokes, there are obviously similarities between the U.S. system and the approach taken in other jurisdictions. Most fundamentally, U.S. courts readily accept the doctrine of competence as a key feature of arbitration. As in other jurisdictions, however, competence is not the final say. There's always a mechanism for review of jurisdictional decisions by arbitrators, albeit the degree of deference by the courts and the point in time for review may vary. Given the variety of approaches adopted in different jurisdictions, reflecting different judgments regarding the proper relationship and balance between the courts and arbitral tribunals, uniformity in treatment of competence across legal systems seems unlikely and arguably even undesirable. Perhaps a more practical kind of uniformity, and one that is hopefully also more readily attainable, is the ability of the parties to a dispute to understand clearly, in advance, the rules on competence that will apply in any given jurisdiction. In this respect, the U.S. system could certainly bear improvement. As a multitude of inconsistent lower court cases have shown, the rules laid down by the U.S. Supreme Court, while superficially straightforward, have spawned not inconsiderable confusion in application. To provide just two examples, what should qualify as clear and unmistakable evidence of the party's intent to delegate arbitrability to the arbitral tribunal? This includes, but also goes beyond, the question I flagged earlier as to whether the incorporation of arbitral rules providing for a tribunal's competence should suffice. And even where a court finds a clear and unmistakable delegation clause, does it really accord with the parties' expectations if the court refers the parties to arbitration despite the fact that one of the parties alleges that the contract as a whole, including but not specifically the arbitration agreement, is unenforceable? While the ability of the parties to shape the arbitral process under the U.S. approach including the timing and extent of judicial review, can bring benefits, including in terms of party autonomy and efficiency, the very real threat of ancillary litigation that has accompanied the Supreme Court's approach risks canceling these benefits out. The Henry Schein case is the latest example of these unintended consequences. Simpler rules regarding the allocation of jurisdiction as between courts and arbitral tribunals, even if they reduced somewhat the autonomy of the parties, could provide an important boost to uniformity and so certainty on the part of disputing parties and courts alike. Thank you.
Thank you.